Good evening, everyone. Wonderful. Thank you so much. I'm Ebony Nelson, Dean of this wonderful law school, and on behalf of the University of Connecticut School of Law, I welcome you to our In Conversation. I thank you all so much for being with us this evening. I extend a special welcome to our UConn Board of Trustees member, Dr. Andrea Dennis-Levine. Thank you so much, Dr. Levine, for being with us this evening. The purpose of our In Conversation series is to bring scholars and the community together to discuss pressing issues facing our society. Another purpose is to model the importance of engaging in civil and respectful discourse when discussing diverse viewpoints, which I must say is needed now more than ever. In this inaugural year, we decided to focus on significant recent Supreme Court decisions, and I'm very much looking forward to tonight's discussion of the SFFA case, examining the constitutionality of race-conscious admissions policies in higher education. As dean, I firmly believe that diversity, equity, inclusion, and belonging greatly enhance the excellence of this institution and of our profession. So discussion of the available tools by which to advance these goals is of critical importance. I sincerely thank our stellar group of scholars who have joined us this evening. Of course, I also thank our Associate Dean for Faculty Development and Intellectual Life, Ann Daly, who has done an outstanding job organizing the In Conversation series. I also thank our events, communications, ITS, and catering staff for helping to facilitate tonight's event. Thank you all so much for coming, and I look forward to the discussion.
Thank you. Thank you, Ebony. Welcome, everybody. I'm Ann Daly, and I'm on the faculty here at the law school, and as Ebony said, I'm the Associate Dean for Faculty Development and Intellectual Life, which is how I'm sitting here in the moderator's seat. And I just want to encourage folks, once you've had a chance to get your food, just come on in and come down and grab a seat, and then we can all sort of be settled here together. So I'm going to begin tonight by introducing our four distinguished speakers, the participants in our roundtable discussion tonight. I'm going to introduce them all at once, and then we're just going to jump. I'm going to give a short description of the case, and then we're going to jump into discussion. So I'm going to start to my immediate left, to your right, is Stephen Rich, who is the Maurice Jones Jr. Class of 1925 Professor of Law, the University of Southern California Gould School of Law. Professor Rich is an expert in the field of anti-discrimination law. His work draws from research in sociology and social psychology in analyzing problems relating to social injustice and affirmative action. In his work, Professor Rich has explored the implications of the court's affirmative action cases for other areas, such as the employment context. Next is Kimberly Robinson. She is the Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia, as well as Professor of Education in the UVA School of Education and Human Development, and a Professor of Law, Education, and Public Policy at the Frank Batten School of Leadership and Public Policy. I got that out. She also directs UVA's Education Rights Institute and the Center for the Study of Race and Law. She's a leading expert on, among other things, education law and policy, educational equity, school funding, and education and democracy. Anticipating the Supreme Court's turn against affirmative action, Professor Robinson has been calling for alternative pathways to diversity in higher education. Robert Thies, next, is a professor of law at BU Law School. He writes widely in the areas of constitutional law and history, with special attention to issues of inequality and the need to identify commonalities among oppressive practices and the lasting interplay between social harms. Professor Thies' work can help us to put affirmative action in the broader history of constitutional equality as we attempt to navigate the best way forward after SFFA against Harvard. So let me very quickly set the stage for what the Supreme Court did in the SFFA against Harvard case. In two earlier decisions, Bakke in 1978 and Grutter in 2003, the Supreme Court upheld the use of race in college admissions as furthering the school's compelling interest in promoting diversity, as long as race was used as part of a holistic review process. In SFFA, the plaintiffs sued both Harvard University and the University of North Carolina. Both schools used race as one factor in a broader holistic review of individual applicants that included other factors such as academic achievement, test scores, extracurricular activities, personal qualities, and letters of recommendation. The plaintiffs essentially asked the Supreme Court to overturn precedent and find that these policies violated the Equal Protection Clause. In the case of Harvard, the plaintiffs argued that the policy discriminated against Asian American applicants. In the case of UNC, that the policy discriminated against white applicants. Chief Justice Roberts wrote the majority opinion. In striking down both policies, the court held the following, and I'm actually going to boil Roberts' long opinion down to 5 sentences. First, the Equal Protection Clause embodies the principle of colorblindness that should guide the court's analysis and requires the government to refrain from making any distinctions based on race, except in the most extraordinary circumstances. 2, strict scrutiny applies, and the policies fail to pass strict scrutiny because the aim of increasing diversity on campus is inescapably imponderable. There is no way of measuring diversity, of determining whether sufficient cross-cultural learning has been reached or students have been adequately prepared for a pluralistic society. And the racial categories employed, such as Hispanic or Asian, are arbitrary and irrational, overbroad in some ways, and under-inclusive in others. Third, affirmative action is a zero-sum game, and the policies hurt some groups. For example, Asian applicants at Harvard, where there was allegedly 11% decrease in admitted students under affirmative action, and the policies promote racial stereotypes about the viewpoints of all members of these minority groups. Fourth, the use of race in affirmative action policies was given a logical endpoint in Grutter of 25 years, and that was 20 years ago. And neither Harvard nor UNC believes that full diversity will be reached anytime soon. As Roberts says, it's 20 years later, no end is in sight. Fifth and finally, the court holds that nothing in this opinion prohibits universities from considering an applicant's discussion of how race affected his or her life in an admissions essay. That was only 5 sentences. Okay. So I'm here to just sort of begin the conversation and perhaps direct it through questioning. And I was going to start tonight with, and by the way, we're going to have question and answer at the end, so with the audience. But I was going to start with the topic of diversity. And Vinay, I thought maybe I could start with you. I want to say that, current events in the world are highlighting both the importance of diversity on campuses as well as the challenges raised by it. Both Bakke and Grutter endorsed achieving a more diverse student body as a compelling governmental purpose to support race-based affirmative action. It emphasized the educational benefits that flow from a racially diverse student body. But Roberts argues you can't measure diversity, categories are arbitrary and irrational, and there's no endpoint. So Vinay, maybe you could start us off by commenting on Roberts' view there, the concept of diversity, whether you might think about it differently, your thoughts on that.
Yeah, I think, Roberts kind of eschewed the precedent on that. We had, Bakke was just Justice Lewis Powell's one opinion that talked about the educational benefits of diversity, drawing from the Harvard plan, and using race just as one factor among many to achieve student body diversity, recognizing, that race is an important part of identity, of, just the social history, social context of our country. Grutter brought 5 votes to that. Justice O'Connor's opinion, we had a majority on the court that endorsed the educational benefits of diversity, that having, a diverse student body has benefits for all students, you know, improves education in a number of ways, exposes students to different perspectives, helps to break down racial stereotypes, you know, number of different educational benefits from diversity. And I think what's interesting is society broadly has kind of embraced the concept of diversity. You know, even those who oppose affirmative action often agree that diversity is a good thing. So I think, you know, Roberts kind of went against the precedent there. Now, the educational benefits of diversity, you know, are hard to measure in some ways, but universities have done the best that they can with different surveys, just looking at the tangible effects of having students of different backgrounds, you know, how they feel about their education, what are the educational outcomes. But that's, you know, I mean, that's not an easy thing to do. And I think the other thing I wanted to say was just the arbitrary racial categories. I think this is something that I see, you know, coming up more, not just in Chief Justice Roberts' opinion, but also in Gorsuch's concurrence and in Thomas's concurrence. It's what I would call kind of the weaponization of the social construction of race, you know, and that's very ironic because it's, you know, kind of progressive and critical race theorists who really promoted the idea that race is a social construct. It's not a biological category, you know, and it's been used for oppressive purposes. But you know, critical race theorists, progressives, acknowledge that it is a social reality. It's very powerful socially. But I think what some of the conservative interests have done, and this was in some of the amicus briefs, they've taken that, the idea that race is not a real category, that it's socially defined, and used that to say, you know, well, it doesn't really make sense to have government racial classifications broadly. And we saw that in these opinions. We saw it in the amicus briefs. And that could, you know, that in and of itself, even, you know, beyond diversity, I think could have all types of ramifications.
Vinay, I don't think I introduced you.
That's okay. I'm in the program, so, you know, y'all can look me up online if you want to. Don't worry about it.
We're out of order on my paper. This is fantastic. Professor of Law, Don Ellen Mabel F. Dickinson, Endowed Chair in Law at the University of New Mexico School of Law. He looks at race from all different angles, interdisciplinary, and I have to mention that his work has been cited in numerous Supreme Court amicus briefs defending affirmative action, including in the SFFA against Harvard case. So thank you. All right, great. Kimberly, do you want to jump in and, you know, your thoughts on diversity, the way that Roberts is looking at it, and perhaps, is it the only way to look at diversity? Are there other, you know, is this a, has the Supreme Court gone in the wrong direction here? Or, you know, your thoughts about sort of diversity as a compelling governmental interest in higher education?
Is that working? Okay, now it's working. Okay, great. So I think what's important to understand here is that when you look at what is or is not a compelling interest, that none of those are in the Constitution. It's really just a policy judgment by the court about what is and is not important. And so what we had in the prior cases is that as a society and as the court said, we value diversity at higher education institutions for the many benefits that it brings. There were over 500 social scientists who presented evidence about the tangible benefits of diversity. So it isn't that it can't be measured. It was simply that the court had decided that it was time for considering race to achieve diversity was over. And so this idea that the very same court who looked at that same evidence and found that it was measurable, it was valuable, none of that evidence has changed. It didn't suddenly, the studies didn't suddenly reverse on their head. There's just a broad array of social science that does show this, that there are benefits, and there are tangible benefits. And so I think it's important to understand what we have in the SFFA case is a policy judgment by the court that we do not want admissions to higher education institutions influenced by race, qua race, in other words, race in and of itself. What the court is leaving open for is the recognition that race does impact people's life experiences, and so basically they're pushing colleges to insist that people explain how race has influenced their experience. But the challenge with that, the shortcoming of that approach, of course, is that, you know, in our very racialized society, you talked first about Robert saying that we are now, the Constitution is colorblind. So there's a long debate among constitutional scholars about the nature of what was intended by the Constitution. But if you look at when the 14th Amendment was passed, there were a number of instances where Congress is recognizing through legislation, laws that were aimed at making sure that the newly freed slaves were provided equal opportunities. So these were programs such as the Freedmen's Bureau that directly provided aid to the individuals who were just newly freed. And I bring that up because that was a racial program that was permitted and enacted shortly after the 14th Amendment. So this idea that the Constitution is colorblind really was not embraced at the time that the 14th Amendment was enacted. And so this is really very much kind of an ahistorical view of the Constitution. It's ignoring that early history and seeking to sort of basically declare by fiat like we've sort of moved beyond race. And that's just not the reality in which we live in today. So
I'm wondering, Robert, maybe you can help situate this in the context of what Justice Powell did in Bakke, which was to say, I mean, sort of along the lines that Kimberly is describing, that diversity is the only compelling interest here, and other interests, governmental interests, you know, such as remedying prior discrimination, are not allowed. And that seems to be, in a way, Robert says to the dissent in this case, you're just trying to implement remedial purposes, remedying past discrimination as a goal, as a constitutional goal, and we're not going to allow it. Maybe you could help us understand that.
Sure. I think it does help to think more broadly about the sort of the long view of things, that for example, to remember that affirmative action programs have been in the crosshairs for going on 50 years, in the crosshairs of not only party politics, but also in terms of the Supreme Court itself, right? And as the composition of the court has changed, we have been on this, they have been on this path for quite some time. This helps us to understand, I think, both maybe the intensity of the feelings around the issue, but also in terms of the narrowness, the increasing narrowness of the terrain on which people are fighting. So once we see that, as Ann pointed out, that, I mean, we kind of need to go back to the late 70s to think about Bakke. And this is a decision, of course, that has over the years been beaten up by both people on the left and on the right. But the Bakke position seems in some ways much more defensible now in hindsight. And more or less what Justice Powell told us back then was, look, race-conscious policies have a role, but we have to be careful. There are times when the power to consider race can be abused. And when it is, then, in other words, we can be reduced to our race, or applicants are reduced to their race, in terms of being assumed that they're either capable of all things simply because of their race, or assumed to be incapable of certain kinds of things because of their race. And so, in a way, what Powell does in the Bakke opinion is to turn the matter of admissions into a question of fairness. What does it mean to be fair in this context? So he doesn't take race off the table at that point, but he does say that each applicant has to be looked at on an individualized basis. And so what was at issue in that case was in UC Davis policy for admissions to medical school. And what really got under the skin of the justices in that case was what they called a explicit two-track admissions process. So in one track, it was sort of straight up test scores, GPA, and then there was another track, and some people could not be eligible to compete on the second track. And so if you were underrepresented minority, then you could compete on the second track. And they looked at that, and their objection, again, was this sort of fairness position, which is that because some applicants did not compete with other applicants, this was, in a way, a kind of a form of social engineering that allowed people to be assumed to be either capable or incapable in ways that are inappropriate. So you step back from that and you say, okay, well, what does that mean? That means that you've got a principle of individualized assessment. As long as universities continue to take that seriously, they reform their policies, they don't do things like quotas and set-asides, then they should be able to take into account things like race, among other things, in order to create a diverse body. But over the years, what we've seen is, of course, then this has changed. And one of the things, going back to the early conversation that we've been having, is that there's a little bit of a talking past one another if we look at the majority opinion in the SFFA case versus the dissents. The dissents accused the majority of essentially overruling all these cases, Grutter, Bakke, but if you look at Robert's opinion, he doesn't do that at all. He doesn't do it explicitly. I do think he's moving the goalposts. So you've got something very complicated going on that can only be understood if we sort of try to understand what it is that the mostly conservative justice have been doing over time, and then that'll help us understand what space remains.
Stephen, your thoughts?
That's a very open-ended question.
I mean, I'm happy to be more specific.
I have some ideas about where to start. So I guess the first place I'll start is with just tracking Bakke to Grutter to SFFA a bit in the following sense. I think what you see exemplified in the Powell opinion is a kind of trust in the judgment of elite institutions. That he reaches for Harvard and says, Harvard got it right, Davis got it wrong. And we trust Harvard to get it right. If you all do it like Harvard, you'll be good, right? But that requires a phenomenal degree of trust in elite institutions. Now, at the same time, Powell was not an originalist. What Powell said about history was, yes, there was Reconstruction, and yes, Reconstruction was about the freed persons who were freed from slavery. But, since that time, between then and now, we've become a nation of minorities, and that equal protection clause cannot be ours. He didn't say it in those words, but that's basically what he said. And now with SFFA, you can see why. Now, Grutter is sort of half measures on these questions, right? Grutter is, okay, well, we sort of trust. We feel like we can kind of trust. We'll trust you somewhat. The terrible, terrible word that gets attached to trust in Grutter is, of course, deference. That's the word that the dissent goes after, right? Deferring to the judgment of educational institutions about whether or not they require diversity. And if it's deference, then it's bad because deference isn't consistent with strict scrutiny, right? Now that gets me to the final point, the final piece in this history, which is the no trust chapter, right? This is the no trust chapter. This is the you are not allowed to have discretion to make these kinds of decisions because we don't trust you to make these decisions because we wouldn't want to make these decisions. We find them inescapably imponderable. And because they are inescapably imponderable to us, they are off limits to you. We cannot verify what you're doing. That's what he's doing. And, that basically says that our rights are limited by what the justices think that they can wrap their heads around. And I guess that makes sense, but gosh, it stings also a bit when you think about it that way. The other thing that I would add to this is so we're here, in a university context, and we've been hearing the term diversity for a very long time, and we have a certain understanding of what it means, particularly in this context. But universities aren't the only institutions that have some claim to defining diversity in the United States. So corporate America has been using the term diversity for a long time too, and that's another important part of the Grutter piece, because Grutter wasn't all-out deference to universities. Grutter was, we can defer to universities because the business community says so, too. They say they need diversity too. They say it's real. Its consequences are real, and we know that because they say so. Now, what that means is that we've got, if everything were going to hang, and now nothing hangs on what diversity means, in my view, I'm sorry to say, so we don't really need to worry about this part anymore. But if everything hangs on what diversity means, if we were back in those days, then we would have to ask ourselves, well, which diversity is it? Because when diversity became a term of interest in corporate America, it was specifically sold as a concept against affirmative action. You've been doing affirmative action, you don't have to do that. Do diversity. Diversity makes better use of your personnel. Affirmative action is a compromise on your standards. Diversity is not. That was the message that was given to corporate America, and the corporate America still is living with, to the extent that they think of diversity as a way of managing a business resource. They think of a diverse workforce as an important business resource, right? Now the reason why I bring this up is that there you have a concept of diversity that at its origins was absolutely orthogonal to the concept of equal opportunity or of equality at all, right? It just wasn't about it. That has somehow become almost synonymous with equality, and now is not any longer. And I think trying to wrap our heads around that movement, right, is, well, it's really important, but it's obviously also incredibly difficult.
Thoughts on this before Kimberly, do you have any thoughts on that? Or?
Yeah.
Vinay.
No, I think the thing about deference, going back to Bakke, it was really grounded in academic freedom, right? The First Amendment, academic freedom, and there was kind of a shift from kind of the notion of equality, remedial rationale, to this notion that universities have this academic freedom. Part of that is selecting their own student bodies, defining their own goals. So that's kind of what was laid out in Bakke and then adopted by 5 justices in Grutter. And I think that move had consequences also, grounding race-conscious admissions, not in a remedial rationale, not in a rationale to achieve social equality, but kind of an academic freedom rationale. But still, Fisher v. Texas, upheld deference to universities on at least defining their goals, their diversity-related goals. Fisher did say narrow tailoring, universities receive no deference. So Roberts went against that also. Now, the majority opinion didn't say that they overturned Grutter, like they did in the Dobbs case with Roe v. Wade. But I think it was effectively overturned because, Roberts said race cannot be a quote-unquote negative factor. And the fact that the use of race, everyone agreed to this. There was a lot of statistical models in this case. But overall, number of Asian American students or percentage of Asian American students would drop slightly if race was not used and everything else was held constant. Now, that could be a lot of variation there. Different Asian American groups, would have different effect. But he basically said it cannot be a negative factor because it negatively impacts Asian Americans in that way. Basic math, percentages are going to add up to 100. And the way I see that, Grutter also said race cannot unduly burden any group. Roberts essentially says it cannot burden any group at all. And I think we see this theme of quote-unquote race balancing, looking at the numbers, which I think is going to come up in future cases also. The focus on the numbers, does it change the numbers? There are a number of cases that are challenging public magnet high school admissions also, and that would be a whole different conversation.
Robert, yeah.
I just wanted to build on top of Steve's point about declining trust on the part of judges, and I do agree with that, and I think that one way to really see that is to compare what's going on in the affirmative action cases over time with what the court is doing in other contexts. And so in virtually every other context, when a question of the Equal Protection Clause comes up, right, the court has found various ways to limit the notion of what inequality is as a concept, made it harder for individuals, for example, to bring equal protection challenges against various institutions, insulating those institutions. So prosecutors' offices, the justice system as a whole, the prison context. That makes the affirmative action cases kind of going against the grain, because here we see over time what the court's doing with its jurisprudence is actually empowering individuals and groups to continue to sue, and making it easier over time for them to intrude into the inner operations of an institution like a university, making it harder, as Stephen said, for a very complicated social organism like a university is to define itself and to hold itself to the world through its policies and admission choices. This is exactly the opposite of what they're doing in every other context, saying equal protection challenges, lawsuits of this sort over time intrude on the well-functioning of these various other institutions. So that's one way to kind of see that, that deep skepticism in this context.
I'm wondering about the relationship between diversity and colorblindness. The court obviously, is rejecting now diversity as, no longer deferring to educational institutions on the question of promoting a diverse student body in race, at least the role of race in that. But the court, both the majority and the dissents, well, both of them sort of lay claim to Justice Harlan's dissent in Plessy against Ferguson. And they also both, they're both also claiming Brown against Board of Education as well. It's like they're coming at it from different perspectives, obviously, but, and what does Harlan say? He says, the Constitution is colorblind and neither knows nor tolerates classes among citizens. My feeling was, reading the majority, that was in part about the means, that government's not allowed to use race-based means to achieve their ends, but it was also about the constitutional ends. What's the ideal? Is the ideal a colorblind society? And is it a post-racial society, I guess? And I was confused by, I think the majority is saying, Roberts is saying, actually, that is the world we want to live in, post-racial society. I was a little more confused about the dissent. It seemed like they thought race recognition was an important pathway to perhaps a colorblind society, a society where race no longer matters, or a post-racial society. So I was wondering, about that, about sort of what's the model of equality? We think about a public law school like this. What's the ideal that's sort of structuring our thinking about it? And I don't know if any of you, Kimberly.
Yeah. So I think what's important to understand, let's just focus on Robert's opinion for a while. He does seem to embrace this idea of a colorblind constitution, but he doesn't take it all the way down. So when he ends the opinion by saying students can describe and share in their essays the experiences that they've had related to race, he didn't have to include that. And so, there are degrees of colorblindness, basically, and his seems to allow universities to still give weight and measure to students who can articulate how race has affected their lives, which undoubtedly elite colleges and universities are undoubtedly being flooded with essays now that are seeking to educate admissions officers about, what it's like to be any number of different minority groups. And so I think it's important to understand that even though he says he's embracing our Constitution is colorblind and sort of echoes Harlan, he doesn't really fully take it all the way down. Now, I say that with caution because he could at some future point take it all the way down, and so I'm not suggesting that that would be the way to go. I just want to highlight within the opinion that there's a tension in the majority between saying the Constitution is colorblind and the end of the opinion that says, but of course you can still talk about it and colleges can still give weight to it, right? So I think that's important to understand. The dissenting opinions particularly are trying to help educate us, I think, about the fact that race, even if an individual student can't articulate how race is affecting them, race is still operating in their lives. So even if a student, even if they can't do that, and particularly I think of Justice Jackson's opinion using the example, I think it was James and someone other, like James and John, I don't remember, yeah, okay, James and John. Two just very simple names, but the point of bringing up one student who was multi-generational alumni from UNC and the other who had never had someone go to UNC because they were African American and had been excluded from UNC. And so part of what the dissent seems to be doing is to explain that race qua race is doing some work here. Like even if the student who's African American doesn't mention that their ancestors were excluded, their lived reality is building upon the building blocks of exclusion. And so I think that is an important distinction that the dissent is pointing out and why they believe that race in and of itself can be considered, because even if you're not talking about it, it is still affecting, you know, the playing field in which we're operating. It is setting some rules and boundaries and foundations in our society. And so that is the reality that the dissent says you can't close your eyes to that and say it doesn't exist. We're all just operating in a racialized society. It was race, you know, there was racism and race at its founding, and we just continue to deal with it, so.
I did want, I mean, I was so glad you brought that up about Roberts and the essays, because he does say that nothing in this opinion prohibits universities from considering an applicant's discussion of a race affected his or her life. But he does go on to say, but universities may not simply establish through application essays or other means the regime we hold unlawful today. And it's actually very hard to know, well, what exactly is that regime you're holding unlawful today? You know, and I think the way you described it, Kimberly, I'm struck by Roberts just being this pivot figure with, you know, just allowing race to come in, but he's not really saying exactly how, and the other people in the majority, I don't know about Kavanaugh, but, you know, generally probably wanting race to stay out entirely, and the dissent, as you eloquently described, talking about the relevance of race to everyone's life. Yes, Stephen.
So thanks for letting me jump in on that. I'm similarly troubled by that last line, right? And to me, it's troubling because then the question is, well, how will you know that we have simply reconstituted, but in disguise, the system that you held unlawful today? Exactly what evidence are you going to rely upon? Exactly what magic looking glass are you going to have? And this is where we get to exactly the other side of the inescapably imponderable. Because I fear a situation in which Harvard, let's say, cleans race out of all of the places in its admissions process in which it existed before, and yet still admits about 25% Asian Americans, and does so for a few years consistently after this ruling. Then what does John Roberts say? Does he say, well, you've been formally colorblind, so that's all I really meant. Formal colorblindness is good, and there's no strict scrutiny here. There's nothing to see, move on. That is the outcome that was forecasted in the opinions of other conservative justices like Justice Scalia and back in Croson many years ago. But is that the Roberts position today, and is that the position of this Roberts court today? I doubt it. And my guess is that what would happen is that they would look at the statistics and they would say, oh, those statistics demonstrate an illicit motivation to racially balance. Wow, well, any of us who knows anything about disparate impact not being a constitutional concept and the very light weight that the court likes to give to statistics when the claimants are black, we would be shocked by that. But I think we better brace ourselves for that. I think it's actually something that could very easily happen.
Robert.
Yeah.
And Vinay.
Just very briefly, I mean, I think just to echo this theme, and again, the one of comparisons, that this deep skepticism built into SFFA and moving the goalposts, I think, through a kind of strong empirical turn. We don't really care anymore what your formal policies say. We are deeply skeptical of admissions officers. They're bureaucrats to us in these elite institutions trying to engage in social engineering. We don't like, we think is interfering with the rights of others. Again, we haven't yet talked about this, I hope we do, but there's a kind of impoverished notion of what education is for and along with what the universities for. But that skepticism reminds me of the skepticism you see when this court looks at agencies, that they also assume or engage in all kinds of social planning that they don't like. Again, talking about faceless bureaucrats going beyond the formal policies to kind of secretly do the kinds of things that are unconstitutional. Very much strong echoes in both kinds of contexts. What's likely to happen? I mean, I think that you're clearly going to have admissions offices get their employees to at least in the stages when they're having conversations, like in the Harvard system, there's individualized reading of the files, and at some point they'll get together in committees, half committees and full committees, and then there's this thing called a LOP process, where they're trying to decide who to keep in the admit pile and who to take out. And this really upset the Roberts majority, because what they looked at empirically was they felt that the people were being kept in the LOP pile, kept in the admit pool simply because they're one race and not another race. So it seems to me that it's at that point it's key to document, right, individualized things. This person had written an essay in which they said that they overcame hardship and so forth, and in part has to do with their race. This could be helpful. This is clearly going to be the strategy that admissions officers engage in. It's also clearly what upper middle class parents who hire advisors to help their kids work on their applications are going to tell them to do. Talk about your race, talk about how you've overcome your hardship. And I'm of mixed views about this. I mean, it's clearly one of the tiny openings left for universities, but whether you get more authentic presentations of the applicants, is a whole different question.
Yeah, I just wanted to note, with respect to the essays, that Chief Justice Roberts mentioned, SFFA, at the beginning of the litigation, one of the remedies they requested, the remedy they requested, was that all references to race be removed from applications. That was their original remedy. Under their original remedy, you would not be able to write essays, or they'd have to be redacted. Anything that could be racially identifying could be redacted. And the reason they did this, their first initial claim was just that Asian American students are discriminated against with respect to white students. The first count in the complaint just focused on that. They brought up everything where Asian Americans were disadvantaged, legacy admissions, athletic preferences, donor children, all this stuff that's not constitutionally actionable. But that was part of the case. That Asian Americans are being discriminated against, and the only way to stop it is to just remove race altogether from the applications. And they, later on in litigation, this notion of implicit bias came up. Harvard has the personal rating where they rate applicants on leadership and humor, social skills, and Asian Americans tend to score lower or scored lower on those ratings. And the district court, although they ruled for Harvard, noted that there may be some implicit bias here, maybe from the counselors, teachers, that the differences in personal ratings have not been fully explained. So SFFA's original remedy, if it had been implemented, would have addressed that if there is implicit bias, because you wouldn't know anyone's race, so you wouldn't be able to have any bias. But they changed that at the Supreme Court. At the Supreme Court, they conceded, SFFA conceded, that race can be mentioned in essays, that you don't have to remove that. So that also was kind of the predicate for Roberts including that in the opinion. I think the other factor was just Justice Jackson's questioning during oral argument and her opinion, kind of raising those issues, those historical issues. I think that's kind of what prompted, the essay exception, or the so-called essay exception. I personally don't think it will have a large impact, but that's, a whole nother discussion.
It has a feel to it of almost like forced speech for applicants, right? And the irony of it actually might force race to be more salient in an application than it otherwise would be. I wanted, though, to bring up the arguments that both Roberts and Thomas make, and Thomas very passionately make, about affirmative action demeaning members of historically discriminated against groups. So Roberts says affirmative action demeans the dignity and worth of a person to be judged by ancestry instead of by their own merit and essential qualities. And Thomas, again, gives a very impassioned argument, really coming from the heart about, you know, the harm, really demeaning Black students, creating a permanent state of victimhood. Can this be ignored? I mean, what do we do with this? Your thoughts about this line of argument? Perhaps how does the dissent respond to it? How do the dissents respond to it? Sotomayor or Jackson? Yeah. So, thoughts?
It's a way of conceptualizing harm. So it's a way of articulating a harm that should be salient from Thomas's point of view to the Constitution. And maybe it's a form of harm that Chief Justice Roberts is interested in giving some credence to, not just when Justice Thomas raises it, but also when the dissents raise the specter of a minority applicant who would be forced to censor the truth about their own life if they weren't able to talk about their race. This is a goalpost that was moved a long time ago. So going back to Adirondack, the court has thought of the harm in equal protection cases as the application of a racial preference to a decision, rather than as the denial of the benefit caused by, where you have to prove causation, caused by the preference, right? And that's a very big difference. If we have this version of harm on one side, what's the other version of harm on the other side? That's I think most salient, and I think that would be the kinds of harms for which affirmative action was initially designed. That is, urgent harms of extreme inequality and literal segregation, not metaphorical segregation from elite institutions. So once you have a concept of harm that's very personal, that's very much about feeling demeaned and feeling like you haven't been treated with dignity because your achievements have been discounted, even though you still get to have them, and even though you got to inhabit those institutions, right? Once that's your concept of harm, and it's just as good as the concept of being fully segregated from an institution, then you get lines like you get in the Thomas and Roberts opinions, where they basically say that affirmative action is separate but equal, that it's equally offensive to the Constitution, that it violates colorblindness in just the same way. That's a very, getting back to the point about ahistorical reading, that's a very ahistorical reading, right? But affirmative action then becomes the culprit rather than the solution. I think of affirmative action like a tourniquet. The patient comes in, the patient's bleeding. You don't want the patient to bleed out. You put a tourniquet on. The tourniquet's not the solution. The tourniquet didn't sew the patient up. The tourniquet didn't create a new state of health for the patient, and the tourniquet certainly didn't prevent the patient from getting harmed again when they went back outside. But at least it saved their life, and it saved their life because they were at a point of extreme need. That point of extreme need and vulnerability is erased by the way in which the court deploys colorblindness, and the pathos of its erasure, right? The reason why experientially this harm hurts and we should take it seriously. That's what Justice Thomas is giving voice to.
Other thoughts?
I do think that this is a pretty good example of a set of ideas that look very different in the hands of progressive jurists. Nevertheless, taking a familiar set of ideas articulated by Ruth Bader Ginsburg about what are the harms that come from state-based policies that treat people differently on the basis of, say, their sex, another attribute that most people think is just an arbitrary fact of life. You're born this way, you're born that way, you're born here, you're born there, you're born into one perceived racial group or another. And in the famous VMI decision, Justice Ginsburg said, one of the harms, the major harms here is there's a set of assumptions upon which the policy is built, that women are not capable of doing certain kinds of things, like experiencing physical hardship in terms of this kind of education, and therefore not allowing them access to do it. And so then the harm gets conceptualized in that way as a kind of dignitary harm that flows from assumptions underlying state policies, and then the state policies perpetuating those pernicious stereotypes, she says. So I think, in a way, this is just sort of the same set of ideas in conservative libertarian hands, that is to say, right? That you've got, when an individual is denied the right to something or treated differently on the basis of race in this context, perhaps in the job context, they're disadvantaged or they're inappropriately advantaged. See, Justice Thomas's example of where his personal experience with affirmative action has become professional. He thinks he says, I've been advantaged through affirmative action, but this has harmed me. So he's like the flip side, like people attach perceptions to my professional life and reputation that these are not earned, and he attributes it to the use of race in letting him into certain elite institutions like Yale Law School. So in any event, so he's got this complicated theory of harm, but it's important to see that, it's a set of concepts that we might agree with in another context, especially when there's an exclusionary policy, right? Someone's completely denied access to something. And it is very different here, but it's the same set of ideas.
Yeah, I mean, I think this notion of harm, I think, comes out in many different ways for a range of different justices. So Robert mentioned Ginsburg, and we have Thomas, but Justice O'Connor, wrote the majority, and Grutter believed the same thing. You go back to her Shaw v. Reno opinion, she talks about expressive harm, dignitary harm, and that's why Grutter was so restrained. She was very clear, we should not use race unless we have to. The race-neutral alternatives should be preserved. It has to be time-limited, has to be done in this way that's really flexible, because we don't want individuals to be stigmatized by race. Grutter almost kind of hid the use of race. If we had upheld the Gratz plan, we would know 20 points out of 150 is about what a university can do. If the UC Davis plan had been upheld, then 16 seats out of 100 is okay. Grutter, we didn't know what's okay. You can use race flexibly, but how much is too much? He said it couldn't unduly burden any applicant, couldn't become a predominant factor. All of this is because she had the same view, that using race is just a societal harm. Just one other note about Thomas, like in my classes, in my race and law class, constitutional law class, I have students, and I will continue to have students read his dissent, Thomas's dissent in Grutter. I think that's a very interesting opinion, because he talks about criticizing standardized tests, that universities want to be elitist, that they care about racial aesthetics, and basically, affirmative action is like tokenism. And I find my students, agreeing with a lot of that. They don't agree with this conclusion, they don't agree with the conclusion he comes to. They think, the benefits of affirmative action outweigh the harms, but they do recognize, that Thomas has some valid points there, or believe that he has some valid points.
Kimberly, I was thinking about your description of Jackson and Sotomayor's dissenting. They're kind of historicizing and contextualizing the issues here. And it seems, harm really seems important there. They're describing a different kind of harm. And in their view, there's not some neutral baseline to which, the healthy person to which affirmative action is acting upon and, is a harm. But there's a pre-existing harm to which affirmative action is the remedy. And I don't know if that speaks to, your thoughts about, what the harm is here in this case, and how we might rethink, address the idea that affirmative action is itself harmful by contextualizing it? I don't know, that wasn't that coherent a question, but.
That's okay. I'll build
You'll-
off,
you can
build
go
off
with
of
it.
that. Yeah. So, I think there's some interesting things happening, just to go back to what Thomas said about this being particularly harmful. In one sense, it's clear that the opinion in many ways is putting an end to what had been the traditional understanding of affirmative action. And in some ways, his opinion saying that there's a harm to African Americans or other people of color who benefit from affirmative action is saying, like, this opinion benefits you too. In other words, you will no longer have to live under this cloud of why did you, what was the reason for you to get in, that is a dignitary harm that needs to be observed. But I think, to Vinay's point about, looking at that harm and looking at the student who may then have elite institutions closed off to them, the fact that they can walk into a less prestigious university without some kind of quote-unquote dignitary harm is not going to set them up for life in the way that admissions to elite institutions does. I mean, the data is very clear that elite institutions or selective institutions really are the pathway to leadership for much of our legal community and other aspects of our society. And so the idea that, take heart that you are not walking under this cloud as you go off to a school that is not as selective, I think is one that, most people of color would chuckle at as like, what planet are you living on? So just to be frank. So I think that it's important to recognize that in many ways, I think that the goal of sort of identifying some kind of harm, dignitary harm in that way, is really seeking to sort of shore up the opinion as like, this benefits everyone. Don't see this as a setback, it's benefiting everyone. And I just think that doesn't recognize the history of what these elite institutions have meant to the creation of the middle class for many Hispanics and African Americans, the pipeline to being physicians, doctors, leaders, all of that the road has gone largely through elite institutions. And so I think it's just, I think of Sotomayor's point about putting lipstick on a pig. That is what comes to mind for me.
Are there other thoughts before we turn to questions from the audience?
I had a quick one just as a kind of follow-up on this concept of benefiting everyone, because I think that's a great reading of the dignitary harm here. But it's also what diversity was supposed to be under individualized consideration, right? No harm, only positive, right? And I'm wondering if maybe the problem is that we are looking so desperately for a single rule that will benefit everyone, as opposed to trying to save the patient who's on the table.
I'm going to just read something before we, be thinking about your question. When we think about the impact of this case beyond affirmative action, how radical a case is this? And I may even have anticipated, perhaps, I don't know, Robert, if you thought the court was actually overruling Bakke and Grutter here. I thought maybe you were suggesting they were closing it down but not overruling it, but others would argue, as the dissent says, and Thomas actually declares, Grutter and Bakke are overruled. So in thinking about that, how big an impact, how radical a case this is what Robert says about the dissent. So this is Roberts talking about the dissent. Lost in the dissent's false pretense of judicial humility is a claim to power so radical, so destructive, that it required a second founding to undo. And now this is the author of the principal dissent, Justice Sotomayor, talking about the majority. The devastating impact of this decision cannot be overstated. So they both sides are seeing this case as or the other party as taking a radical position and as a radical judicial institution. So with that, I'd like to open it up now to questions from the audience. So Deb, do you want to? Yeah.
Hi. Oh my gosh. Hi, I'll direct this to the whole panel. I'm a 2L here. My name is Colin. My question is, we've been having this conversation in the context of the understanding that, we're applying strict scrutiny here. But when having this conversation, should we not be also talking about kind of some of the assumptions made in the decision to use strict scrutiny itself? And what I mean by that is, we apply strict scrutiny with the justification that it is to address a suspect classification. And the suspect classification that's used for this case is race. But is there really a justification that white Americans can claim to that? Can they really claim that there is this history undermining, that there's a history behind discrimination that's giving justification for them to be placed on the stage to have suspect classification so that strict scrutiny is applied to them as well as to other groups? We've talked about kind of the fluid nature of race, and I think understanding the doctrine, I don't know, I'm interested in your thoughts on should we have more fluid interpretation of how race is a category?
So the court has really embraced a suspect classification in a way that it's not about the past discrimination that the individual has experienced. So I take your point to be, interrogating, perhaps there should have been maybe lesser scrutiny for the claims that were being made. And the court has really kind of adopted this very uniform standard for once it says a particular classification is a suspect classification, then anyone who is claiming that particular classification gets this type of scrutiny. That was true for gender as well. Whether it was a woman or a man, you were getting intermediate scrutiny. Whether you're white, black, or green, it's going to be strict scrutiny. And so the court definitely is seeking really some consistency across the category, in part because, the idea that the court would pick and choose a level of scrutiny tailored to racial history, I think is, really a bridge that the court would not embrace in terms of how to interpret the Constitution, in part because that the level of scrutiny likely would shift, largely based upon who is sitting on the court. So they really have kind of consistently embraced a type of scrutiny once you establish the particular category, for better or worse. So.
Yeah, I mean, that is what the court has done, taking this anti-classification view that any racial classification is bad. Any formal racial classification is something, government should avoid using. But the grand irony here is if you look at the SFFA v. Harvard case, from the beginning, the history of Asian Americans, discrimination against Asian Americans was at the forefront of the case, and it was in the opinions too. So they talk about the history of discrimination in that case. Justice Thomas, goes back to Japanese American internment during World War II, talks about the Chinese Exclusion Act. So it's in the discourse, even though it's not in the doctrine. And it's just, interesting how it was used in the discourse of the SFFA cases, even though that's not what's legally relevant.
So I think this is a really great question. The move from suspect classes to suspect classifications is extremely consequential, right? It's consequential in part because it takes the history of the group's subjugation out of the question. And in other areas of law, we are concerned about the vulnerability of the victim as a way of understanding whether or not there was a violation of a duty to them, or what the extent of the remedy should be for them, right? So it's odd in some ways that we would strip that from this particular question. I think that the consistency point, the idea that the court is just not comfortable with applying principles inconsistently based on who's invoking them, that seems to be what's going on. But I also think that we got here by a route that it's sometimes hard to see. So in the 70s, when the court did finally decide to raise the level of scrutiny of sex-based classifications, the first articulation of why in Frontiero by Justice Brennan says, well, women are like racial minorities. They have a history of discrimination. Oh, and by the way, what makes them women is a condition of their birth, which they have no responsibility for, so it's an immutable characteristic. The sex cases, it made it a great deal of sense in the sex cases to apply the same standard to men and women, because very early on in the sex cases, what you were facing was, so take the near beer case, right? Near beer case was men should be older than women in order to get access to near beer because, well, young men are irresponsible and they're likely to do dumb things and get themselves and other people hurt when they use near beer, but not women. The negative stereotype was about men, the positive stereotype was about women, except that everybody in the room knows that the positive stereotype's not so positive. And so psychologists have this concept of ambivalent sexism. It makes a whole lot of sense to protect men against stereotypes that are applied to them because of their sex as a way of protecting women against stereotypes that are applied to them because of their sex, right? You're doing both. It's two birds with the same stone every single time. That's not necessarily true with race, right? But this is an idea, though, that the consistency idea then comes right through the 1970s and into the affirmative action cases of the late 80s and 90s. And so I think that there's a certain way in which what we thought was progress in one area may have been a negative in another, if you think that the sex cases or the way that the court approached the sex cases affected its understanding of what's wrong with race in the race cases.
Question?
Hi, I'm Will. I have Crim Pro in 8 minutes, so I'll try to keep it quick. I think my question has been danced around and even mentioned a little bit, but I don't know if there's a satisfactory answer, but I'll try to pull it out. So it seems that now we've moved away from, I guess to boil down my question is, where do we stand after this decision? Because we've moved away from the different percentages of classifications. We can't define what a racial classification is, right? That's imponderable. And the court has now moved away from those because those questions were imponderable, but now, as was mentioned, it's also imponderable how we analyze the impressiveness of an applicant now in light of these rules, or almost lack of rules. Because when we assess an applicant, there's always going to be inferences that are made, maybe even stereotypes that are made. So where do we stand? What rule can we draw from this, if there even is a rule? Maybe there's no answer, but.
Where do we stand?
Okay, so I'll jump in here. So I think that you are going to see selective institutions still seek to ensure that they have diverse student enrollment. And they will do that because of the research I referenced earlier, that if you have people who are largely similar in an institution, you just don't get that different sort of possibly life experience or other things that can help you enrich the learning environment. And so institutions are quite committed to diversity. So I think that they will approach diversity of the student body in several ways. I think they, one, will seek to increase the pipeline. So they will seek to expand who is applying to schools, and that will be across demographic groups. It will not just be, there will be some targeted recruiting, but I think we're going to see more money and resources and people directed at recruiting than we've seen in the past. Because in many ways, affirmative action was doing some of the work. It was, people were aware that this existed, and so now you're going to have to encourage people to apply more in a way that didn't happen, as well as doing even the more challenging work of helping more students be prepared to be successful in the applicant pool. And that's a program, that's an effort that can benefit students across demographics, right? Oftentimes, you know, you see in law schools, I hear this at my own institution, I hear students say, wow, a lot of my classmates describe their dads who are law partners and their uncles who are judges and their, you know, moms who are law professors. And it seems like, you know, the people that largely got in often have really come from strong kind of legal families. And so part of what the effort is focused on at my institution and elsewhere is to make sure it's a broader cross-section than that. And so I think that is actually a move that's going to benefit many people to expand the pipeline of who's going to be sort of prepared to apply and encouraged to apply. I think then in admissions, you are going to see admissions officers really continuing to look at the multi-factor, you know, multiple factors for people that will consider essays, but also will still consider many other things, such as overcoming hardship. It could be coming from a rural background where you don't have as many educational experiences. There's just going to be an array of things that are considered. And then I think also the other things that's going to happen, you are going to see a dip in the racial diversity of elite institutions with the end of affirmative action. And because of that, institutions are going to need to put more time, energy, and investment into retaining the students that are there. Because it is a more challenging environment to always be the only or always to be one of three. And so there's going to be a lot of effort focused on making sure that the students that you do admit who are likely to be fewer in number actually stay and graduate. So I think you know, I know because I do this work in education, that the higher education community is very much looking at a holistic response to this decision. And I think I personally think that's a move that is long overdue. In other words, one, the writing was on the wall for affirmative action for a long time anyway. It wasn't going to make it. That whole 25 years in Grutter, it was coming, right? It's just a question of when. So I mean, it's not a surprise. It was just really a timing thing. And so I think part of what I believe is that, you know, in many ways we relied on affirmative action when what we should have been doing is trying to expand the opportunities that students have across all demographics to get a high quality education so that we have more students who are ready and prepared to succeed in elite institutions and non-selective institutions. But we're really not doing that work. We're doing a whole lot of wringing our hands about this decision, but we're not having conversations like this in convenings to say, like, all students should be getting a high quality education. It shouldn't be this narrow subset that's prepared for these institutions. And that is really just goes to the core of our fundamental values of, you know, having a just and fair nation. So that's really a conversation that I work a lot on in my own, my work in just having launched this new Education Rights Institute. I work on expanding educational opportunity for all students so that they can have a better shot to go to whatever school they decide to go to.
Yeah, I'll just add another development in recent years is that 1,800 institutions of higher education have either stopped considering standardized entrance exam scores, the ACT, SAT, or have made them optional. So that may have an impact also because there are racial disparities on scores on those tests. Now, what kind of impact that would have, whether that will continue. Part of this happened not just because of these issues, but because of the COVID-19 pandemic and the difficulties of testing during that. But Harvard itself, I believe, until 2026 suspended or made the use of the SAT, ACT optional. What will be the impact of that? I think, it depends on what replaces those tests. If it's more holistic admissions, well, holistic admissions also can tend to benefit more students from elite backgrounds because they can get the college counseling, the coaching to do their applications in a way that appeals to admissions officers. But I think you'll see a number of different moves just in the way that admissions committees consider not only these holistic factors, but also academic factors. I mean, will grades, GPAs, test scores take on a greater role? But then we have the phenomenon of grade inflation. Even looking at high school grades, how much they've increased in the last 20, 30 years with the average GPAs across high schools. There's been studies done on that also. So does that shift, if academic criteria are more leveled out, does that shift focus back to holistic admissions? Does that lead to the same bias? Unfortunately, I think selective elite institutions are, probably going to remain no matter what the admissions policy is, but, people from elite backgrounds are going to have an advantage.
I think that might be, do we know where we are? I think we might be at the end of our time. I want to say it's a hopeful note that was just ended on, that there may be unintended consequences from Robert's case if, in fact, we start to look more deeply, maybe go back through to high school, maybe even earlier in thinking about the pipeline to colleges and even law schools. So anyway, join me in thanking our panel.
Thank you.